So today we have a longer episode with Dr. Jennifer Cobbe and Dr. Heleen Janssen from the Universities of Manchester and Amsterdam. It's probably one of the more philosophical episodes that contemplates law in the face of rapidly changing technologies and changing interdependencies among people. Emerging technologies like cloud computing and encryption, COVID, the reemergence of the Cold War have all been massive catalysts for change that everyone has witnessed in their lives. If you take a step back, you will see that your own web of interdependencies has probably changed, and societies as well. And if you take a moment to reflect on that, you will start to see the importance of that construct for interpreting what the law is or should strive to achieve. The law isn't merely statute and precedent. It is a complex web of interdependencies constantly evolving. Although discussion here relates to GDPR and privacy specifically, it applies more broadly to any emerging technologies, including, of course, the laws that touch encryption. To really develop the right mindset about how to approach a rapidly changing world with shifting interdependencies and technologies, you really need to take a step back. Perhaps the figuration perspective of law discussed in this episode and policy is the right place to start. If you enjoyed this episode, please share it. And if you enjoyed this episode, please share it. And now I bring you Dr. Jennifer Cobbe and Heleen Janssen. Welcome to The Encrypted Economy, a weekly podcast featuring discussions exploring the business, laws, regulation, security, and technologies relating to digital assets and data. I am Eric Hess, founder of Hess Legal Counsel. I've spent decades representing regulated exchanges, broker-dealers, investment advisors, and all manner of fintech companies for all things touching electronic trading with a focus on new and developing technologies. So, on today's episode, I'm so excited to introduce Heleen Janssen and Jennifer Cobbe onto the podcast. They are both senior researchers and lecturers at the University of Cambridge. Heleen is also a researcher at the University of Amsterdam. They focus on privacy, law, computer and technology, a lot of topics, a lot of expertise to draw from. And I'm really excited to get into this episode with both of them today. They've both written a number of papers collectively, which they'll cross-reference throughout the podcast, but we'll also drop it into the show notes for people to check out independently. So welcome.
Hello.
So typically we start off with a little bit of background on each of you and what sort of made you particularly interested, or that personal experience that made you very interested in the privacy and even the legal component of it and the relationship space. Maybe we'll start with Jennifer and then Heleen.
Sure. Yeah. So I think for me it was really, I was coming out of my undergraduate law degree, and I was thinking about, what is it about law, and what is it about the concept of law and the area of law that I've been studying that I'm particularly interested in. And not long afterwards, when I was doing my master's degree, which was on, excuse me, that's really bad. Not long afterwards, when I was doing my master's degree, which was on the law and questions around governance and these kind of bigger picture questions about law, the Edward Snowden revelations about the NSA's and GCHQ surveillance practices kind of came out. And I'd sort of been interested in surveillance and questions of power and that kind of thing that come from surveillance for quite a while. And I'd written some of my undergraduate and master's degree sort of essays and dissertations on these kind of questions. And whenever the Snowden stuff came out, that was when I thought, this is really interesting. So I got into the kind of state surveillance kind of question, the question of, what kind of powers do states have to surveil the internet, and what are they doing on the internet, and what should we be concerned about? And that very quickly moved into, who else is surveilling all of us on the internet, and what other things are happening? And of course, all the privacy and data protection and surveillance questions that come up from all the platforms that we use every day, and all of those different things. So from there, it kind of snowballed into what I work on now, which is much broader than just sort of those quite narrow surveillance issues. But that's sort of 9-10 years ago. So it's taken 9-10 years to kind of get to the point where I am now. But I think it's been a fun journey, or I say fun journey, it's been a slightly terrifying journey somewhere along the way as things have gone. Things seem to be getting progressively worse, but I'm still relatively optimistic about this, and hopefully we can push things towards a better direction in future.
Well, optimism is good. And Heleen?
Yeah, thanks, Eric. Yeah, so, well, I have a long-standing career at the Ministry of the Interior in the Netherlands, where I was working at the Constitutional Affairs and Legislation Department. So, yeah, I have experience with lawmaking, but also with the nitty-gritty policy making in many areas. My background is in constitutional law, or let's say public law, but during my work at the ministry, I've seen many other areas of law coming by. And as of 2006, the ministries or the government got more and more interested in using technologies. They weren't called new technologies at the time, but they saw it upcoming very swiftly. And as of that moment, I got very interested and tried to focus in my work on this area, and how it relates to the law and how the law should respond to issues that come with these technologies. Yeah, just to give you an example, I've been working on, I worked on constitutional legislation. So I led a project on the modernization of the right to communication secrecy. Another thing I did, for instance, is that I internationally negotiated the revision of the Council of Europe's Convention of Data Protection. I did that on behalf of the Dutch government. Another area of law was where I negotiated for the European Union's Equal Treatment Directive. There are many of those, but the one I was working on at the time was equal treatment of men and women where the access and supply of goods and services are concerned. A very exciting time that was. And I also contributed to the revision of the Dutch Intelligence and Services Act. Yeah, that was also a very exciting time, and not always easy, because you're very much split between. I have my own background from a constitutional fundamental rights perspective. At the same time, you see that the powers are going elsewhere. So yeah, you question sometimes what is the work I'm doing here? Does it make sense? To be honest, that was sometimes challenging, but yeah, as a person, you might sometimes feel torn apart between two worlds. Yeah, and then at some point I really longed back to academia again, and that is where I started to work at the time with Jennifer. That was in 2018 with the University of Cambridge. I'm still connected to the university, but I also got back to the Netherlands, where I started working at the University of Amsterdam. And mainly my focus is on questions of data governance at the moment, issues of power and control. I have been working and focusing pretty much on decentralized modes of data processing, thereby focusing on personal data stores and on data intermediaries at the minute, where I focus within the Cambridge circle on the technical side of things. And in Amsterdam, I look more at the practicality of things. So I think I'll do that. Thanks.
Great. We're going to start off taking sort of a step back and maybe more of a philosophical and a sort of policy-driven approach. Jennifer Cobbe wrote a paper, or is writing, I should say, a paper on a figurative or figuration analysis and its application to law. Both Heleen and Jennifer have worked a lot with these concepts. So, but to sort of set the stage, could you introduce the concept of figuration and its application to law, and I guess social, economic, political policy settings as well?
Yeah, sure. So figurations is a concept that was put forward by the German sociologist Norbert Elias really over the course of his career from the 30s through the 70s. And his basic argument is that all people everywhere at all time throughout history have been involved in essentially a huge number of interdependencies with other people. And these interdependencies come from the idea that people can't really exist in the world on their own. You only exist in the world in relation to other people. And by that, I mean, no one person can be born completely alone and go through their life on their own and then die alone. At some point, you have to rely on other people. Nobody can perform all of the things that they need to do themselves to be able to survive. So Norbert Elias says that we each perform functions for each other, by which he means we each do the things that each other need to survive and to live and to thrive in society. And these functions produce interdependencies between people. And everybody is in these, as he says, these fluctuating webs of interdependence, because he's also very big on the idea that everything is a process. There's very little in the world that is ever static. Everything is constantly changing. So these figurations that are formed through these webs of interdependence are constantly changing. They're extremely dynamic and fluctuating. And they all come with these balances of power that operate within and across and through these figurations. So power, in his view, comes from the fact that we have to each perform these functions for each other. So if you're dependent on one person, then they possibly have some kind of relationship of power with you by which they can provide these functions. So that's kind of his basic idea. It's all about relations between people. It's all about functions performed by people. It's all about these webs of interdependence. So what he says is that if we want to understand human society, and if we want to understand how people exist in that society, then we need to understand those figurations. And I think that's a pretty powerful argument, because I think its essential observations about the nature of human existence are correct. So what does that tell us about law? Well, that's a really good question. What it tells us about law is that much of our current approach to law, which is based on the idea that there are discrete individual people that can kind of be easily distinguished from others, I think the Figurations analysis tells us that that's kind of based on an incorrect assumption. I think it tells us that actually, if we want to be able to understand how people act and why people act and how law can intervene, then we need to have a figurational understanding of their relations. Ultimately, law is in large part about governing people's relations, or at least about trying to govern those relations. So if we want to try to govern them, then we need to understand them in a sophisticated way. And for me, I think Figurations offers that sophisticated approach that allows us to put those relations in a broader context. But it also allows us to understand that law isn't the only thing that covers relations and isn't the only thing that can structure figurations. Because law exists as part of these sort of ever-changing, wide-ranging social processes, these fluctuating webs of interdependence, these figurations, law is only one influence among many. So we need to understand the interrelation of law and the interrelation of law and the relations it wants to or is trying to regulate or govern. There's a whole lot of other processes, including technological processes, social processes, political, economic processes. We simply can't understand law by considering it in isolation, just as we can't understand individuals and their role in society and their relations by looking at them in isolation.
And in the context of a society or that's moving toward online ecosystems more, where a lot more of those interactions are governed in the virtual space or even through automated processes, whether it's payment mechanisms or effectuation of contracts, does that increase the issues with a sort of a static perspective of law? Does it not have an impact at all? How does the greater web of online interactions factor into a figuration analysis?
Yeah, that's a great question. And I think one of the things that is kind of underappreciated or perhaps needs to be considered when talking about these things is that technology itself can foster forms of interdependence between people and can alter the forms of interdependence between people and can lead some people to perform other functions for others that they might not necessarily have been performing before, and can afford different kinds of structure to figurations. So when we talk about technological processes like moving into the kind of things that you were talking about, and also say, for example, the shift into things like cloud platforms and the kind of forms of centralization that we saw with that, sort of as a kind of contrast to the kind of decentralization that we're beginning to see in some other areas. I think what we see is that those different technologies have fostered different forms of figuration and different forms of relation, different forms of interdependence between various people, whether it's the individual users of platforms or of people who are engaging in these kind of contracts or whatever else, or whether it's the platform companies or people who are trying to develop decentralized kind of protocols. Those kind of different technologies and the way that they've contributed to structuring figurations have changed rapidly in the last 10 to 15 years. And the way that the law has been set up simply has not accounted for this. The law is still trying to govern these figurations or trying to structure these figurations in ways that arguably made sense 15, 20, 25, 30 years ago, but didn't make sense by the time we got to the massively centralized kind of web of the last 10 years, and make perhaps even less sense as we get into perhaps a slightly different way of doing things in future. So if we want to be able to have laws that can properly regulate and govern the kind of relations and interdependencies and figurations that we'll see emerging in these technological ecosystems in future, then we need to really very seriously rethink the fundamentals of these laws, and also and understand how those figurations work and what the best way to go about trying to structure those relations and interdependencies might be.
And I guess love to get your thoughts on this, Heleen, as well. Does a static approach to law tend toward a more of a top-down approach? And is that one of the reasons why different models of contemplating interdependencies becomes more important?
I think possibly, yeah. I mean, I think there's this sort of traditional legal view of law is that you have, you have a legal text or a legal framework that is passed by a legislature and it's interpreted by a court, and that's law. That's kind of roughly how the beginning and end of law. Of course, there are much sort of broader kind of understandings of law coming from things like critical legal studies, or in the US, they have the legal realism movement, or sort of social legal kind of approaches to law. But I would say that actually law is never static. It's never a text or even a text as interpreted. Law is a process. Law is a process that begins with people deciding that they need to try to govern relations in some way, or even before that, some kind of processes that produce a set of relations that people then decide that they need to try to intervene upon in some way. And laws are passed and interpreted and applied and contested in constantly changing circumstances and constantly changing contexts and in constantly changing ways. So although you might have a legal text that seems to be relatively fixed in some sense, our understandings of it, our interpretations of it, our applications of it, and the way that it's contested changes constantly and all the time. Law is constantly in flux in just the same way as anything else in society. And I think it's really important to understand that law is not done in legislatures and courts. Law is done throughout society. And it's not just formal legal text, it's also the norms and the ways that we together try to regulate our relations with each other and govern our behaviour. A company like Facebook, looking at data protection law and deciding how it can comply, or as might be the case with Facebook, not comply with it, they're doing law just as much as the people who passed GDPR in the first place are doing law, because law is a living thing that flows throughout society and structures figurations everywhere at all times. But it's a very imperfect process. All of these other processes, the technological processes, the social processes, the political economic processes, they're equally at the same time structuring those figurations. So law has these infinite and infinitely complex interactions. It's all of these other things happening at once. And it's this broad process of law and its interactions with all of these other things that I think we need to very, very seriously investigate and begin to understand if we want to have laws that can possibly hope to contend with the state of technology today, let alone the state of technology in future.
And as it relates to balances of power, I know that's a part of the figuration analysis and legal artifacts. Do you want to discuss the role of balances of power in a figuration analysis?
Yeah, so I mean, power is fundamental to human relations, and it's not just the sort of Norbert Elias figurations kind of point of view that would say that. It's essentially the whole of social sciences has been making that argument for the last century, and I think that's something that's really still underappreciated in law. It's the more critical kind of views in law, the more socio-legal views in law have really grasped this idea that that law is about power. Law as a process is a manifestation of power and of these other processes of power throughout society. And law's interpretation and its application and all those other things I talked about are just as much a process of power as anything else. But power is fundamental in figurations because power is ultimately what determines how those figurations function in practice. It's the functions that people perform for each other produce interdependencies, and interdependencies produce balances of power, and that's what really controls and governs relations. And those balances of power can come from law. They can come from other kind of ways that we have of relating to each other, and they can come from political, economic factors. They can come from technological factors, social factors, really anything else. But power is the fundamental sort of constitutive element of all human relations everywhere. And law is perhaps the most obvious and the most socially acknowledged sort of form of that power or manifestation of that power. But fundamentally, law is the core power. Is the core unit. So whenever we talk about law and we talk about figurations, you can write a law and you can pass a law and you can anticipate that it might be able to do one thing or another, but it won't do those things if the power balances that underpin those figurations don't match up with what the law is trying to do. There's very little point in legislating for something if there's no power that can allow that thing to happen, or permit that thing to happen, or enable that thing to happen. The law can say what it likes, but something else is going to happen, and that's something that again I think is kind of underappreciated when it comes to law, and also when it comes to society in general. The fundamental importance of power to everything.
Yeah, I really like the approach taken, the holistic approach, which is so necessary in this discussion. And just to add also a position that I often brought in from a legislative perspective when I was working for the government, is of course we heard those ideas that people were complaining. Law is so slow, it doesn't really moderate with the modern technologies, all those kinds of complaints, very well known. But at the same time, as Jennifer rightly said, law is in the middle of things. And that's what I used to say. Law isn't static at all. It is constantly enticing people and forcing perhaps people to go into a dialogue with each other. Law is never finished indeed. So even when you have the highest court in your country or in a regional system saying this is how this law should be interpreted, there still is space for a legislator to enter into a debate with society, but also with a court, and that is what should happen. And then on the other point, where law is seen as it dominates a sort of structure. Well, law isn't over and on top of people and of societies. It is right in the middle, in between and amongst people in society and institutions. I agree very much with what has been said here.
And when we talk about balance of power, and I'm thinking in terms both privacy and digital asset regulation, and honestly probably applies to regulation impacting any new technologies that the law hasn't fully caught up with, right? Is the notion that with the balance of power and a figuration analysis, that initially the balances of power can change dramatically as society begins to adapt. There's a new influx of technology, then there's a reaction to it by regulators because, we missed this, we missed that. And maybe there's a shift in that power balance until that now counteracts some of the benefits of the technology. And then there's a readjustment, meaning larger shifts in balances of power during the inception of the regulatory framework governing any new technology that over time perhaps moderates as there's sort of a consensus view reflected both in the legal system and in the non-legal social conventions.
I think I would take issue with the idea that law is falling behind technology, or that law as a phenomenon can fall behind technology at all. I think I would say that all technologies are inherently a product of their time, of their place, and of their context. Even simple technologies are kind of embedded in these much broader processes and long-term social, political, and economic and legal developments over time. I think technologies are fundamentally social phenomenon, produced in societies and used in societies, and either adopted or kind of set aside in societies. But part of the context that produces these technologies is law. So technologies can structure figurations in the way that I talked about before, but technologies themselves are products of figurations. And we know that law is a fundamental aspect of figurations as well, and of the balances of power in figurations. there's no technology that can be separated from the law that operate in that context, or from other influences that operate in that context. And kind of the social nature of technologies, and the fact that technologies are inherently kind of embedded and situated within these social processes, is something that I think is really important to understand for if we want to talk about whether balances of power in technology and law, and whether how they relate to each other, and how law can deal with these things. So, for example, the ancient Egyptians invented the first steam engine, and it was essentially a wee small turbine that they used as a toy to, like, look what steam can do. Isn't this really exciting? They had no use whatsoever for it as something that became in the Industrial Revolution, which was for steam engines, for transport, or for mills, or whatever else. So when it became realized that steam and the properties of steam could be used in certain ways and could be harnessed in certain ways in the Industrial Revolution, that was because the political, economic, legal, social context of the time meant that there was a need for technologies that could do what steam could do. Which means that the technologies themselves are it's not necessarily the case that technologies change balances of power, but the balances of power also produce technologies, or produce the social circumstances in which technologies are developed and adopted. So it's a much more complicated, much more cyclical, much more symbiotic relationship between all of these things than is commonly assumed. We see as well, for example, writing, for example, we think of writing as being a really basic technology. But writing is developed in lots of places at different times. In ancient Greece, for example, the very earliest form of writing in ancient Greek was in palace administration. And it was found for keeping records and for that kind of thing. And we're talking hundreds of years BC when this was happening. And it was written in Linear B. That was the kind of alphabet, or it wasn't an alphabet because they used symbols to represent the syllables. But whenever the late Bronze Age collapse happened and the palace system kind of fell away and the palaces disappeared, so too did writing. There's no evidence of any writing for several hundred years until writing in the ancient Greek alphabet eventually re-emerged, or in the Phoenician alphabet eventually re-emerged several hundred years later. And that was used almost exclusively for recording poetry. So it wasn't used for the kind of writing and the kind of record keeping and public administration that had been used before. It wasn't another century till it was used to write laws. And it wasn't until much later than this that it was used for commerce and administration. So even basic technologies like writing that we think are so fundamental to civilization only ever get used in certain ways when their social, economic, political, legal context allows them to be used, or provides the need for their use. So we can't separate that from the other things that we've been talking about. So if we want to talk about, do technologies change balances of power and figurations that then need legal responses? Absolutely not. Balances of power produce technologies that, of course, can themselves have an effect in changing the interdependencies and functions in figurations. But it's not the case that the technology comes first. Everything comes first, if you know what I mean. Everything is cyclical and processual.
I think the examples that we have seen across many countries coming up during the COVID pandemic with the technology, or the so-called COVID-19 apps that had to help governments to control what was happening in public space, for instance. We have seen that happening here in the Netherlands as well. And the expectations were very high, but many people in government really forgot about the fact that what are you measuring and how does that play out on people's lives? So they didn't take this broader view on the consequences that the use of such a technology might have for people, and they didn't, in other words, consider the more holistic aspects or the socio-technical aspects that such a technology would bring. The government was in fact saying, so here's the technology, and the technology is going to regulate your behavior. Which is the other side of things, and which we really shouldn't want. But at the time I was advising the ministry from the fundamental rights side of part of things, but they didn't want to listen. There was a very strong tech solutionist attitude in this. So the belief that technology will solve many problems in society, and that is one of the dangers where lawmakers then are sometimes lagging behind, because they jump on this wagon, and they think we are going to do this with the technology.
How does a legislator or a lawmaker, policymaker, faced with regulation relating to a particular technology or impacting a technology, how do they actually implement sort of more of a figurational analysis? Or framed differently, how are they ignoring it today in some cases?
That's a great question. Yeah. I think one of the things to mention, to talk about, is that regulators, like everybody else, are kind of to some degree constrained by the sort of the limit of what people have decided collectively is possible, or the way of thinking about things that we've decided collectively is possible. And collectively, as a society, we all live in sort of very liberal, well, not liberal in the sense of being completely open and free, but liberal in the sense of liberal philosophical tradition societies that are individualist, and societies that have, particularly over the last 40 years, but over the time before that as well, have decided that actually state intervention in the economy or in other areas of society should essentially be limited to some extent managing risks. We really shouldn't have proper state intervention in these things, but the state can manage the risks that are brought up by business to try to keep people sort of vaguely safe, but really it's up to them to sort themselves out. And if you grow up in a liberal tradition, and you live in a liberal tradition where that is how things are done, and law reflects that. Law itself has very individualistic kind of normative foundations and ways of thinking about the world that are promoted through law schools and through people who have any kind of legal education or legal experience. If you're working as a regulator or as a policymaker in government, then you will be thinking in that way. It's not that you're sitting down consciously thinking, we don't want to know about these other things that influence how these figurations are structured. Of course, they wouldn't use the word figurations because that's not a thing they would be thinking of. But it's just that your limit that the people of all kinds, including policymakers and regulators, tend to be kind of constrained in their thinking by their socio-political experiences and the things they've learned as they've grown up and moved into the world. So they're not sitting down and thinking, we don't want to be doing these things. It doesn't occur to them that they should be thinking about these things. It's not that they're ignoring figurations, it's that they probably don't even know that way of thinking about the world exists. And they don't know that potentially law could be done in a completely different way, because how would they know that? Nobody's ever told them that. So I think that's there are institutional problems, cultural problems, things like that. It's not so easy as how do regulators and policymakers think about these things, because they think about these things in the same way as everybody else thinks about these things, which is deeply flawed.
And so how do we, where does it start? Does it start with a broader discussion, or are there more actionable things that could be done if policy, if we were to influence policymakers to incorporate more of a figurative analysis, or lawmakers?
I think that's a question for Heleen. She's worked in government. She would know exactly how to go about doing that kind of thing.
Yeah, I think
no pressure.
So I'm happy to be away from that. But many lawmakers and policymakers have been subject to is this new public management thinking, and I've seen very, very much quality even policy making, and that is very, very saddening, because every much is very brought down to processes and procedures only, where strategic departments, they have all been economized out, and other useful areas where people were thinking with each other, where they were meeting each other, where there was time for let's say the IT specialist and for a lawyer and a policymaker to sit together and to discuss things. There's no time for that. Everything is very, very much made flat and straight and mean and lean. So there is no quick solution, in other words, in this area. So what I've been working on, for instance, is I tried to design a fundamental rights impact assessment. And many people may say, well, what do we have? We already have 25 of these kind of things. But my take would be, it's a process where you put people together and you force them to discuss certain questions together. And you do that in a certain order. These questions come up in a certain order. But what you definitely want is that at some point the right people are on the right table, and that they together have to take a decision with consensus. And it's not only the IT department that is taking decisions, or it's not only the lawyers taking the decisions, because everybody oversees or overlooks, they may overestimate their own importance and may not rightly value the importance of other areas that need to be involved. So I think, in the long run, there may be solutions that can be thought about, but there are no quick wins in this area, I'm afraid.
And do you think the hope of getting a more figuration-based analysis would exist with policymakers and legislatures versus the agencies that are charged, or ministries that are charged with enforcing and interpreting them?
That's interesting. I mean, from my point of view, the distinction between those two is kind of less important than you might imagine, because they're all kind of part of the same process of producing law and applying law, and the role that law plays in society that I kind of talked about before. So I think it's actually about a much bigger project of changing how people think about the law, and changing how people think about the role that law plays in society, and how law works, and how we need to think about these things. But yes, absolutely. I think if you can change how people involved in any aspect of that process can think about how they go about doing their work, how that process needs to operate, and if you can inculcate people to think about things in terms of the functions that we're performing for each other and the interdependencies that gives rise to, and how you might go about structuring a law or writing a law or interpreting or applying a law in such a way as to properly account for those interdependencies and to produce the kind of legal, well, I call them legal artifacts. They're kind of constructs of law, so things like rights and obligations and entitlements and that kind of thing. But also something like personal data is a legal artifact because there's no such thing as personal data, and it's created by law as to be any information relating to an identified or identifiable natural person. That's how the law defines it, and it's created by law in that way. So anyway, to get people to think about how we construct legal artifacts that can account for those interdependencies, but also can help create functions or produce functions between people that change those interdependencies. So by giving people rights and effective rights against each other, you can, to some extent, go about trying to change those functions that underpin the interdependencies. But simply doing that and simply leaving it up to people to do that themselves, that is never going to work, because the balances of power in figurations are usually far beyond the ability of any one individual to properly change. These are structural systemic problems. So what you also need is a much bigger, broader kind of set of artifacts and frameworks that together can help change those balances of power through functions and interdependence. But without doing that, we're kind of still stuck where we have been with existing law, which is very much individualistic and very much leaving it up to people to do jobs that they simply can't do themselves. So it's all well and good getting people to think about function and interdependence and power, but until we understand that actually individual people can't change figurations, you need to have a much broader, kind of more systemic approach. That's not really going to get us anywhere. So we need that change in thinking away from individualism and away to a much more systemic way of going about things as well, I think.
And so maybe even using, I know you touched on it with the reference to personal data, but how are current regulations, particularly GDPR, but you can point to other jurisdictions on privacy or whatever you want, how do they fail to properly contemplate figurations and the over-individualization of data subjects?
That really comes to the core of the problem with data protection law. So data protection law, the first data protection laws in the world were passed in the early 1970s. I think the German state of Hesse had the first data protection law of anyone, which was passed in 1970. And I think off the top of my head, Sweden had the first national data protection law in 1973. Heleen, I'm sure, will correct me if I'm wrong. And of course, then there were things like Convention 108 in I'm definitely going to get this wrong, but 1981. Is that right? That's right. Okay, 1981. And sort of then the growth of like European data protection law in 1985 was the Data Protection Directive. Then the Lisbon Treaty put the European Charter of Fundamental Rights into core EU law in 2008-ish. But fundamentally, a lot of the core concepts and principles of data protection law still originate with those much earlier kind of approaches to data protection law, so things like Convention 108, which, like I said, is from 1981. And it's very possible that those forms of data protection law work really well for the kinds of processing architecture and the kinds of processing figurations that you saw develop at the time. But they don't work well for the kind of processing architectures and kind of processing figurations you see now, because the functions and the interdependencies and the balances apart are completely different. Not just because the technological developments have changed how those figurations are structured, but also because legal developments have changed things, social developments have changed things, political economic developments have changed things. All of these things together have helped completely change, transform the figurations that we see around data processing today compared to what they were 30 years ago. And the law has fundamentally failed to keep up with that in any kind of meaningful way. So the law will tell you, data protection law, GDPR, will tell you that there are essentially three key actors in data processing relationships, one of which is a data controller. He is the actor responsible for the purposes and means of processing, which is to say, they determine how and why processing is occurring. One of them would be a data processor, which is somebody that the data controller has kind of said, well, you process this data on our behalf, but they're only acting under the instruction of the controller in principle, and are kind of a very sort of like secondary subordinate kind of actor compared to the more dominant controller. And the third is data subject, which is construed in law to be a very individual person, an individual person on their own. Now, in principle, that made sense back 30 years ago when a lot of processing might have been like personnel records, and the controller might have been your employer, and the data subject might have been the employee. So that kind of worked for that kind of scenario. But now you might have things like really complex cloud processing services. Like think of like artificial intelligence services, where the producer of the system that is being essentially rented out of the service is somebody like Google or Amazon, some ginormous, exceptionally powerful, exceptionally wealthy, exceptionally capable multinational company who holds all of the technical expertise, and their customer, who might be some random person, who runs a very small business without any technical expertise at all. And in that scenario, in most cases, in many cases at least, Amazon or Google or Microsoft is going to be the data processor, the very subordinate kind of party in that relationship. And actually somehow this random person who doesn't really know anything about the processing is going to be the controller, or the dominant person who's supposed to be in charge of all this processing and is somehow supposed to have control over how all this is taking place. That just doesn't make any sense whatsoever. In that situation, quite clearly, the dominant party, the party with the way that those functions and interdependencies are set up, quite clearly the party with all of the power in that scenario is the big multinational company who actually controls the systems, not the small guy who's kind of using their service. So the law is completely backwards for these kinds of things. And when it comes to the individual data subjects, you've got this very serious problem in that the law fails to recognize that technological processes can create interdependencies between people. So if you think about the business models of a company like Google or a company like Facebook, it's not so much about the data of individual people, it's about the data of many, many people aggregated and then analysed fully, and then interventions taken against them, and decisions made and that kind of thing. But data protection law puts all of the obligations on individual people in terms of, or all of the responsibility on individual people in terms of protecting their rights and in terms of making complaints to regulators and that kind of thing, but it still treats them as individuals when they're not, because the processing creates those interdependencies with all of the other people whose data is similarly processed and similarly analysed, and they're subject to the same kind of interventions, because the choices made by one of those data subjects has effects on all of the other data subjects because they're treated collectively in these business models. So because law individualizes data subjects, what it actually does in effect is it individualizes them into these forms of capitalism, and doesn't give them anything like the tools or mechanisms or legal avenues that they would need to actually be able to protect themselves. So the law fundamentally fails on quite a few different fronts because it completely doesn't recognise how processing operates today and the effect that has on the figurations around this kind of processing today.
Yeah,
Heleen?
I do agree that GDPR was really set up, focusing on individuals. At the same time, you see some initiatives or ideas coming up, and some of them have been sort of successful. Is that people have started to exercise their data rights or data subject rights, as you can find them in the GDPR. So these are the rights that give you as an individual the right to access the personal data that are being stored about you in an organization. And there have been, this is mostly encouraged by NGOs or organizations that seek to empower, for instance, workers over their rights. And some people have started to consider these data rights maybe as, they are intent agnostic. That's the idea. And instead of a person only asking access to the personal data, you do that with a certain specific goal. And this is, for instance, where Uber drivers here in the Netherlands and in the UK, they started here a case in front of the court here in Amsterdam, and they said, we have, let's say, I think it was 20 or 30 drivers that collected, that exercised their data rights, and from that they could extract how their data were processed, because they became comparable, and that is indeed the element that Jennifer just mentioned. It is so much individualized that data, we all know that data at individual level isn't that interesting. It becomes interesting whenever it's being analyzed on a collective basis. And what these people did, more or less, is they said, this is what we can derive from the data that we collected. And there were many more, there were other examples here as well. But they could demonstrate that they were paid inadequately, that they couldn't exercise their ordinary workers' rights. And they said, we want to be treated as workers. And that's what the court allowed them to. And so these are maybe very teeny tiny light points in the future. But I do agree that the GDPR as such is very, very much focused on individuals.
On that point, it's about the points, the data subject rights and that kind of thing that Heleen was talking about. I think those are potentially very useful rights that might actually find some way for like organization or groups of people, like Heleen mentioned, like the Uber workers, to try to sort of challenge what's going on. Absolutely, that's fantastic. I think fundamentally the problem though is that they are essentially individualistic rights. They apply to individual data subjects, and they allow individual data subjects to manage the processing of, or in principle, to manage the processing of their data. But those people are themselves subject to a whole range of other influences and interdependencies and things that make it essentially impossible in many cases, if not most cases, for them to actually do that in any kind of meaningful, informed kind of way. Not to mention the fact that people have their real lives to be getting on with, and they really shouldn't have to spend all their time trying to do this. But for me, the fundamental problem is that through data protection law, the kind of control of processing that you are in theory supposed to have through your data protection rights, often, or most of the time, becomes somehow trying to exercise control over or to manage the data processing figurations that are composed of all of these actors, with all of their functions and interdependencies and power balances, when the data subject is, in the vast majority of cases, going to be by far the weakest party in those figurations, and is somehow then expected to try to manage them themselves. I think that's completely unworkable and unrealistic, and that's the core problem. It's not so much that those rights can't be useful in some circumstances, but for the most part, it's just completely unrealistic to expect it to work.
And so I want to introduce a concept, and I want to. It's not we're not segueing into it because we're not leaving the figuration analysis, but something that Heleen has worked has written a paper on, which is personal data stores, PDSs, right? For those who aren't familiar with PDSs, it's probably more of a retention of data on a hard drive, your own personal devices. We actually had a podcast recently with Poly, a data cooperative, which is sort of built on this notion of retaining data in your own on mobile devices and then interacting with processors by permissioning. But PDSs, and I'll also include in that category broadly data wallets. So, in other words, whether it's in a PDS or in a data wallet, this notion of having control of your own data, this notion of choosing to interact with the parties that that want to process that data versus necessarily turning over all rights. Now, again, if you allow them to interact with it, they may be retaining that data, but perhaps through permissioning or privacy enhancing technologies, the information that they get is actually limited, and they can be restricted to just what they need for their purposes. Today there's sort of this approach where there's so much data that these large central stores get, these controllers, and not all that data is needed, and so it causes this huge repository, and that also impacts the data subject's rights, because there's just data being collected and aggregated versus just getting what they need, which would be sort of managing their rights possibly better. So anyway, with that segue, Heleen, do you want to talk a little bit about personal PDSs and how they relate to this figurative analysis? Figuration analysis, not figurative.
Personal data stores, I think they are a great hook to discuss this figurational angle, as they try to figure themselves as a new way for individuals to exercise control over their data. We have seen, interestingly, I think we have seen several initiatives come up. Personal data stores, the idea isn't that young, actually. People have started to think about these approaches as of 2013-14, so they have been around for some time. But to date, we haven't seen really successful and broadly spread initiatives, and I think that is one of the things to consider, maybe. So why don't people embrace those things on a broad scale? One of the things, and maybe to come back again to the individualistic approach that you also see in the GDPR, you've also find it in personal data stores. They are very much focusing on individuals, offering individuals a certain service. And one of the things maybe really overestimated is that people don't have the time to interact with very many personal data stores at the same time. Okay, you can have one, but the question is very much, okay, you have your personal data store, but you also have a couple of other apps and systems that you interact with on a daily basis as an individual. So the question is then whether personal data stores really add to people's lives. Not to say that personal data stores, they also require, on general levels, they require certain expertise or knowledge over how those systems work. So what are you consenting with whenever the system's asking you, do you want to have this service? Can we use this or that data for the service, or any other questions? And the point in case is also that, with personal data stores, your personal information, as long as it stays in your personal data store, it will be relatively safe. But once it goes beyond your personal data store, once it moves from your device, the control is gone. So these are some aspects that they are systemic. I mean, you cannot work around these. I think. Just to say a few.
Jennifer?
Yeah, I think PDSs are a really good and interesting example of how sometimes decentralizing the processing or decentralizing the storage or whatever else of the data doesn't necessarily decentralize the power or change anything else that matters in these complex kind of environments. So obviously a personal data store means that you're processing the data locally on device, and it's decentralizing that processing does then change the functions that you're performing a little bit, in the sense that you're now performing processing for Facebook, whereas they were performing that processing themselves. And that gives you, to some extent, some degree of control over that processing. So in principle, that makes complete sense. And through that, you can kind of alter those interdependencies a little bit. But although you're changing those particular functions and interdependencies arising from it, you're not really changing other functions and interdependencies that arise in these complex processing environments and ecosystems. So, like, for example, if I want to contact people on Facebook, and like my mom uses Facebook, if I needed to contact my mom on Facebook, then, or through Facebook, or do whatever you can do on Facebook, I don't use Facebook, so whatever you can do on Facebook, then I would probably need to use Facebook, or at least some other platform that my mom uses, or whatever, that probably ultimately uses the same business model, because this business model is extremely widespread. Or it could be another platform that actually is just owned by Facebook anyway, like Instagram or WhatsApp. My sister-in-law, for example, as well, needed to be on Facebook because her daughter's school would send out updates about whether school was closed, if it was a snow day or something like that. They would send out those updates through Facebook. So you kind of had to be on Facebook if you wanted to know what was going on. So the fundamental problem, I think, with personal data stores is that the technological elements of these things are just one of the various things that influence figurations. And actually, there are a whole lot of other things as well that help structure figurations and structure the power balances in those figurations. So choices over data are often severely limited by social and political economic realities. And personal data stores don't necessarily, or really at all, change those other things. They might be useful as part of a much broader systemic and structural kind of change, and actually could be very useful in some circumstances, I think. But unless we have that much broader change, I'm not sure personal data stores are going to achieve very much.
You certainly don't want to mandate technology, because that's you ultimately stifle the next phase of innovation. So we talked a little bit about how the individually focused model de-incentivizes the assertion of protections. How do we move toward, like, what is the model where you're not, as an individual, required to assert your rights? Because I agree. I mean, all these rights to the individual, we'll get into that a little bit later, but any single individual really may not be motivated or incentivized to assert those protections, that they really just want it done for them. They have X number of minutes a day to devote to this, if that. It's like cybersecurity. You don't want to worry about cybersecurity. You have to worry about cybersecurity. It's good for you to worry about cybersecurity. You actually may be more motivated to worry about cybersecurity than privacy, because cybersecurity can impact you with dollars and just ways, and a lot of pain. And on the other side of that, privacy can also do that. But at any rate, what is the right model? We talked about, like, how GDPR looks at you have your data processors, you have your data controllers, you have the subjects, you have these three classes that have different rules or rights associated with them. How does this notion of broadening the individual rights out, how does that factor into that construct, or does it not?
So I think cybersecurity is actually quite a good or interesting analogy, because cybersecurity experts have, I think, long ago concluded that if your point of failure in your cybersecurity is people, individuals, then your system is going to fail at some point. And because people are just terrible at this for a whole number of reasons that are, to be fair, largely beyond their control, because most people don't have the time or the interest or the understanding or knowledge, and really shouldn't have to. And I think I say the same thing about data protection. We make a lot of data protection enforcement and oversight. We make that dependent on individual data subjects acting responsibly and managing their data and all that kind of thing. And when we make a key point of failure, the individual person, then the protections will fail. It's guaranteed. It's inevitable. I think people shouldn't have to sit and manage their data protection, much in the same way as they shouldn't sit and have to manage cybersecurity. the average person in the street is simply never going to do it. And it's unrealistic to put those obligations on them when we know that. You're just victimizing people. And I think if we've got law that fundamentally exists in principle for the protection of people, as data protection does, the whole point of data protection isn't about protecting data, it's about protecting people from interferences with their fundamental rights caused by the processing of personal data relating to them. And if we're going to have a legal framework that's constructed with the purpose of protecting people, then we can't, in doing so, go about victimizing people and putting them in positions where they're simply incapable of being protected. I think that's a completely wrong approach. But unfortunately, it's the approach that the law has ended up with because it hasn't been updated properly, like a root and branch from ground up principles forward kind of update in 30 years, which is what the law needs. So what can we do to try to do something about this? Well, I think first of all, we'll have to make sure that there is an understanding of the fact that actually data subject rights and data subject mechanisms can actually be important and useful. So things like the right of access to personal data is an important and useful right, no doubt, but it should be completely decoupled from the oversight and enforcement against data controllers who are acting unlawfully. Nothing should depend on data subjects being these kind of engaged, active citizens going about, in a responsible way, because that's not reality. Of course, people should be able to lodge complaints if they want to, but actually we need to really decouple these things to a large extent. And I think we need the law to understand that it doesn't make sense to talk about an individual data subject in many kind of contexts. Now, it might be the case that in some contexts it does make sense to talk about individual data subjects. That's fine. But in other contexts, it doesn't. So I think what we need actually are forms of data protection law that are kind of more particularized to particular sectors or particular kinds of processing, where actually a more collective approach might be better in some than in others. The kind of one-size-fits-all data protection law, which is kind of GDPR has moved away from to some degree, but is still kind of the core logic, is kind of, that's not really suitable anymore. We have processing architectures and processing figurations that are completely different from others, and applying one set of laws to those things doesn't work. So we need to have, within the ones that I think we need in future, we need to recognize that the data controller and the data processor kind of substantive roles that we have now simply does not work for a lot of things. And we need to fundamentally rethink how that works. But in terms of individuals, we need to start treating people as collectives, and we need collective mechanisms for protection of people. There are other ways in which, other areas in which protecting people collectively, so example like health and safety law has some kind of collective protections, or environmental law has collective protections. We need to be looking towards those for inspiration to decide how we go forward.
Yeah, I've been looking into approaches where it's not mechanisms, where entities, I should say, they call themselves data trusts or data commons. There are proposals underway where those entities or people developing those, so they are not there yet, but they are being developed in scholarly environments, particularly in the UK. Is that you have, you can broadly say a data intermediary, or such a data trust, where you have an organization that is taking care of your rights on your behalf in some way. Well, I think one of the questions that these, whether you like them or not, or whether you would accept them or not as representing you vis-a-vis data controllers, leaving that discussion aside, but they are pretty much struggling with the question of whether the GDPR would allow such an organization to exercise your rights, your data rights on your behalf, and that's also something that we are looking into in Amsterdam. So zooming out again, the question whether such that would mean there is an organization that would exercise your rights on your behalf. You can be very critical about this at the same time, because once such an organization is exercising your data rights on your behalf with a lot of other people's rights, there are generally more people involved in such a data trust. Now the question then arises: would you trust such a data trust to exercise those rights on your behalf? I think there are very many things to consider, but this is one of the ways forward that is currently being looked at in scientific, in academic circles.
Yeah, I mean, I think in terms of things like collective protections, a lot of the law is kind of very procedural in nature. It's all about how your processors doing things, or how controllers doing things, and are they doing risk management, or are they taking steps to mitigate potential problems, that kind of thing, which is kind of that's very much part of the course for regulation in sort of our particular context, and actually in the world in general at the minute. I think what we need, and to some extent, are just much more substantive protections. We need to say, actually, you shouldn't be allowed to do these things. We should have certain things that are just prohibited activities with personal data. That would be a collective protection, because it would protect everybody equally, regardless of what it is regardless of how well they engage with their data protection rights or whatever else. And I think mechanisms for overseeing and enforcing those kind of substantive hard protections would go a long way towards solving a lot of the problems, or at least some of the problems that we've seen with processing today. Although we should also acknowledge, I think, that when it comes to data protection at the minute, one of the fundamental problems is that too many of the data protection regulators are extremely underpowered, or extremely under-resourced, or just have no real interest in actually enforcing the law. Some of them, in particular in Ireland and the UK, are exceptionally ineffective. Some of them were slightly better. France's one, CNIL, is a little bit better, but the UK and Ireland in particular are absolutely terrible as regulators. They seem to completely misunderstand what it is they should actually be doing, and seem to have very little interest in applying the law, rather than just helping tech companies figure out how to do what they want to do, sort of vaguely within the bounds of the law, which is kind of not really the job of a regulator. So I think we also need mechanisms to make sure that regulators actually do their job properly, whether that's allowing data subjects to take enforcement action against regulators through the courts, either individually or as groups, to force them to uphold the law, or whether it's in the EU, for example, having mechanisms or better mechanisms for the European Commission to bring infringement proceedings against member states who haven't resourced their data protection regulators properly, or haven't made them enforce the law properly. But ways of creating other forms of interdependence within all of these various actors that might strengthen the position of data subjects by protecting them better, but also might strengthen the ability of regulators and data protection regulators to actually intervene and do something about this.
Yeah, you raise a few interesting points there. Not to say everything else wasn't interesting, but the enforcement is an issue, even with all the laws in place. Enforcement's an issue, and there are organizations like NOIB who are very active in sort of keeping the regulators honest. But what a job they have, huh? And so there's not many organizations quite like NOIB that are out there, doing things like that, championing the rights of the individual data subjects. That's one. And then the other thing that's really interesting, and perhaps is a risk that develops over time, is the notion of regulatory capture. If you're a regulator for privacy, you're going to be able to score well-paying jobs in the large tech companies that are the ones who are most active in trying to comply, and it creates a sort of revolving door where that experience is valued in the agency, but also that experience in the agency is also valued even more in the private sector, and sort of it encourages. We have that a lot in the regulation of pharmaceuticals. We have a lot in the regulation of financial services. I mean, it's across the board. Whenever you have big industries being regulated by regulators over time, that's going to sort of result in some inherent biases within the system, because it's not that people are out there actively conspiring. It's just that they naturally gravitate toward that framework of understanding things in the context of, we're the big players. And it creates, and the other component of that, and we're actually going to talk about that, actually, maybe it's a good segue, is it creates moats, protections for the big players. Smaller incumbents have a barrier of entry into highly regulated markets, because they have to sort of address these regulations right out the gate. And maybe we'll talk a bit about this in the context of technology startups who are struggling with this as well. You both worked on I think 2 papers and a study relating to this, and I'll leave it to one of you to sort of introduce the paper and what it was endeavoring to achieve in the study. And I don't know if Heleen or Jennifer want to start.
Yeah,
Heleen,
well,
go for it.
You've been voted.
yeah.
We've been volunteered
Yeah,
for
well,
this, I
in
think.
this paper, we interviewed, or the first author, who was Chris Norval, he interviewed, I think, 15 companies, startup companies, in how they went about the GDPR, what it meant for them, what it entails for them to be compliant, and whether they think they can be compliant. And these interviews were taken right before the time, or a little bit after the time, that the GDPR entered into force. So there was a lot of uncertainty for those tech startups. And what we saw very much emerging in those interviews is that people didn't really have an idea. And they said, well, this is a risk-based regulation, so who are we to substantiate to this, and who are we to give substance to our own actions and decisions? So it was very, very difficult for them. But it doesn't mean that you, as a startup, you can say, well, I don't know, and I don't care, and I cannot take this responsibility. So once you enter this market where you want to process personal data, you have to deal with it. At the same time, what we saw was that, okay, they may not have the knowledge, but they still have to abide by the rules. Is that these tech startups of today, they can be the big players of tomorrow. And so what we thought, and what we thought would be a very good approach, is that, particularly regulators seriously consider this, and that they help those tech startups in becoming compliant, or maybe saying the big companies may perhaps consider how to help those with a bigger purse to comply with the GDPR, how to help those tech startups. So that was an exciting paper, and it has many times I've seen.
It's interesting. I mean, startups are often, I think, a kind of under-considered kind of topic for data protection discussions. But something I said before is that law is done throughout society by people interpreting it and applying it and contesting it and trying to navigate their obligations and trying to comply with it. So those startups are doing data protection law just as much as anybody else in that kind of law process is doing data protection law. So I think they're just as important as kind of areas of inquiry for us as academics trying to understand data protection law and trying to understand how the law works out there in the real world, rather than sort of like, in our textbooks and what have you, and our articles and what have you. Then those things are really important to understand. How are people actually going about doing this in the real world, and what is their understanding of the law and of the obligations that apply to them, and of how they should go about trying to comply with it. And what we found with the startups was that a lot of people were really keen to comply with the law. Quite a few of the people that were interviewed really agreed with data protection law. They really thought that it was an important thing to protect people, but just had no idea where to begin with it, because they saw it as being this kind of overwhelmingly complex thing that they would have no real way of dealing with. And I think that speaks to a lot of misconceptions about data protection law that have been about for quite some time, because actually the core obligations of data protection law are not particularly complicated, and have been the law for, at this point, 25 years. So people who are coming into this space should ideally have some kind of expertise or understanding of what the law says. But these people just had no idea. They found it so complex and so overwhelming that they just kind of retreated from it. And that's a major problem for law, because, like I say, people are doing law everywhere. These startups are doing law, and if in doing law they're just not complying with it or not applying with it the way they should, then that means the law doesn't exist or isn't effective in the way that it should be. in relation to their products and their services, and it also ultimately means then that the people who are using their products and services are simply not going to be protected the way they should be, and that's a massive, massive problem. And I think a lot of the onus has to be on people like the ICO or on organizations like industry bodies who have the expertise to try to help startups understand what their obligations are and how they
What
should.
does ICO stand for?
Sorry, the ICO is the Information Commissioner's Office, which is the UK's data protection regulator. To help
this audience will get it confused with something else.
To help these startup companies understand what their obligations are and comply with them, because until we have this more proactive approach to making sure that data protection is kind of, I mean, the law says that everybody should be implementing data protection principles from the ground up in systems design, but we know that doesn't happen. And without the more proactive approach to try to make sure that happens, people are going to be left unprotected, and that's not really good enough.
And so from a tech startup's perspective, I read the study and I saw a lot of issues that were raised by the tech startups. Some wanted more prescription. There was, to your point, there was confusion about, hey, what do we do? How do we do it? Of course, if you are prescriptive, then it raises a whole bunch of other issues because they don't always apply. It makes interpretation difficult, and that can worsen the situation. So, given that tech startups, they're starved for resources, probably fundamentally, they just don't want to have to worry about it right now. Like any startup, they want to focus on how they actually succeed and get traction versus comply with regulations. How do we address that? Because I mean, even if you say, well, we'll take this cohort and we'll make sure that they talk to the ICO, et cetera. I'm not saying, there's always, it's always coming in, right? There's always new tech startups. There's always new technologies, new things that are being challenged with. How do you, the smaller set of companies versus the bigger ones where they're tooled, they'll have a data protection officer in-house or a data privacy officer in-house. What is a solution?
I think from my point of view, I mean, look, legal and regulatory compliance is a kind of requirement. It's a non-optional requirement, not just in tech, but also, I mean, in virtually any sector of the economy. One of the most fundamental things that companies need to do, as indeed everybody else needs to do, is comply with the law, because the rule of law is one of the fundamentals on which, democratic free society is based on. So we need companies to comply with the law. And if a company is going into business without the resources to comply with the law or without the interest in complying with the law, then they shouldn't be going into business. It's simple as that, I think. They need to come back when they can afford to do it or when they have the interest in doing it and do it properly. It's quite a hard line kind of approach, I think, but the rule of law is fundamental to free society. So let's make sure we uphold that over the interests of, tech people in starting their startup and doing whatever it is they want to do.
Right, and maybe there's also a role to introduce these companies to technologies early on that would allow them, where they could just basically design around some of the limitations that the law might impose, specifically privacy enhancing technologies or encryption. Like if you can, I've talked on this podcast many times before that data is like, personal data is like plutonium. It's radioactive, it's toxic. It's something that, as a company, you're incentivized not to have more than you need. Doesn't mean that you actually adhere to those incentives. It doesn't mean that you develop infrastructures that solidify your structure where you're centralizing it because you found a way to comply, but yet you still have all the data. Do you think that has a place, sort of like, maybe like the ICO doing more to sort of say, here are some solutions you can utilize or solutions like them to facilitate compliance, and you should be building it at the outset?
To some extent, yes. So things like privacy enhancing technologies might be useful for some businesses, though I would be wary of the idea of companies using privacy enhancing technologies to get around the limitations of law, because very often the limitations of law are there for a good reason. And if you try to get around them, then there's a good chance that, well, you might get away with it, of course, because data protection regulators are kind of pretty useless. But there's a good chance that you could find yourself in kind of hot water because you've got try to get around a limitation of law and just kind of ignore the fact that there's a reason why that limit exists, and you can find yourself in more trouble. But also because of the need to protect individuals and the people and societies at the other side of these technologies, or the people impacted by these technologies. Again, those limitations exist for a reason, and it's usually for their protection. So yes, absolutely, if you can do things within the bounds of the law and use privacy-enhancing technologies in a way that protects your users or people affected by systems, while also making it easier for you to comply with the law, then fantastic, do that, and absolutely should encourage people to do that. And industry bodies and regulators and anybody else relevant should encourage people to do that. But I'd be much more hesitant about the idea of using privacy-enhancing technologies to get around the law. I think that way is a dangerous route to go down.
Maybe try to think of different models of how you organize regulatory oversight. That might be a way to go.
All right, and you actually, in your paper, you had I liked your chart, by the way, your infographic with, I guess, the solutions and the, stakeholders and all the different, possibilities. I also noted that the privacy by design emphasis was sort of like the top left. And I think, Jennifer, to a large extent, you're saying like privacy by design means you start off by design, factoring this in. And maybe there are tools like a privacy impact assessment that could assist you with that as well. How would you envision sort of this the collective rights of the individuals being better accounted for in privacy regulation? I'll footnote that you noted that some things you don't even necessarily need to have the engagement of the user to do, that they should just be fundamental, that these are things you cannot do with the data and then you don't necessarily have to worry about or rely on the individual exercising those rights. But do you have any other thoughts about just even ensuring that the collective interests are represented in the legal system versus I guess relying on sort of a top-down approach of saying, here are things that are in the interest of the collective?
I think something I'm quite interested in is the idea of kind of, I assume, in the US you have like ombudsman and that kind of thing, who are kind of empowered to act, to investigate problems, to kind of bring proceedings against problems or on behalf of people who've been affected by something. So in the UK we have, for example, what's called the Parliamentary Health Service Ombudsman. And it's the job of the Parliamentary Health Service Ombudsman to deal with complaints from individuals about the activities and actions and policies of public bodies. So like, government agencies and that kind of thing. And I think an ombudsman kind of idea for taking problems that are clearly of a collective nature affecting data subjects and investigating those complaints and then passing them on to the regulator for things like enforcement or whatever else, or themselves bringing proceedings against them. And of course, you could potentially merge the kind of ombudsman regulator kind of function into one kind of body that is empowered to act in that way. But that would need quite a fundamental restructuring of the regulator, I think. But some kind of data protection ombudsman might not necessarily be a bad idea, though ombudsmen have their own problems and their own limitations, but it would be an improvement over what we have now. I also think strengthened rights for things like class rights, class actions. GDPR has some very minimal class action rights contained in it, which have been, in the UK at least, even more restricted by recent court judgments. But I think actually class action rights for effective action through the courts, not necessarily for compensation, because a lot of data protection harms aren't really quantifiable. But in terms of forcing data controllers to comply with the law, I think could be potentially very useful mechanisms. But perhaps some kind of recompense for data subjects, but I'm not thinking of punitive kind of damages or anything like that. But it's more about forcing compliance with the law. So those kind of collective mechanisms where you can have essentially somebody leading on a class action, but it can encompass the sort of the privacy or data protection infringements of a wide range of a number of people, might be a potential way forward. But there are also other ways that we could look at from other kind of areas of law. And I don't want to get too prescriptive about it at this point, because I think it's not clear exactly what the best way to go about doing this would be. But certainly we have things that we can learn from and things that we can do that are at least worth trying, because they would be better than what we have now.
Heleen, do you have any experience with, like, I guess, in terms of the government, like who had in the Netherlands, who had that responsibility for sort of acting on behalf of the collective outside of the regulators, for ensuring that the policymaking decisions and the privacy regulations were acting in the interests of not just the individual subjects,
Yeah,
but
at the
the
time I was
collective
working
interests?
there, I recall from discussions from back then that well, people were really open to these to this perspective, but at the same time also hesitant. Would the courts not be overburdened and that kind of things. Meanwhile, there have been successful, let's say, collective actions. Well, as I just mentioned, with the Uber case in Germany, there was, for instance, with OpenSUFA, there was this case where an NGO asked, I think, like 4,000 people to exercise their data rights for them and to collect the data and to collate the data, to analyze it. And what appeared from that what appeared from that exercise is that a credit registering organization in Germany, the biggest one in Germany actually, the credit scoring organization, that they were taking discriminatory decisions. So yeah, again, an example where where the collective action, to pinpoint this one, can really be of big help. And this is where the organization, so SUFA, they had to accept that their practices were found to be discriminatory, and this was a huge reputation damage for them.
Yeah, I mean, there's multiple components to it. It's you have, the fact that personal data may not be protected. You have, how it's being utilized. You have bias in decision making and how that impacts the data subjects or even the class of subjects. So all those factors are of important consideration. We don't have too much time left. Is there anything that we haven't touched on in this podcast that you think maybe we should, to sort of give more context to what we've talked about thus far?
I guess something I've been thinking about lately is, and this is kind of connected to a lot of what we've been talking about so far, is the role of gaps in law in allowing things to happen and permitting things to happen or facilitating things to happen, and in through that helping structure data processing figurations or indeed other kinds of figurations in any kind of way. We've talked an awful lot about what the law does and about how the law might do things differently, but we've talked very little about what the law doesn't do and how we might redraw those gaps or redraw those spaces in laws, and whether we need to, and what the effect of those gaps and spaces might be. And I think legal inquiry in general is exceptionally uninterested in that, because people in general working in law tend to think, well, we need to look at the law and its effects rather than the spaces where there isn't, say, GDPR applying and the effects of that, or the ways in which GDPR doesn't define certain things and what that kind of aspect of it might look like. So that's something that I would encourage people to think about a bit more, because I'm going to try to think about that a bit more, because I think it's important and underappreciated.
Yeah, nothing to add.
Yeah, I guess we could do another podcast about what the law doesn't cover. But the enforcement of it, the enforcement of existing laws. I mean, in many ways, if the law today isn't necessarily protecting the interests in the way that it's structured, you almost have to wonder, like, do we have to get the construct right before we can start layering in other requirements that may fall into the similar issue? Like, perpetuating the problem. So I think the figuration analysis, in reading it, like I was talking to Jennifer before the podcast, it just really struck me as to how useful it would be to just sort of think about it in a law in a much broader context, and that in many ways the non-legal components of the system are as meaningful as the legal components, and all of these things work together. And in many ways, when you start to isolate the different components, you miss the interrelation and the interdependencies of them all. So this was a great discussion. Thank you both for joining the podcast. It was great to have you on.